with various prestigious university law schools and national law schools. Sir has pursued Master of Law from Sri Venkateshwara University, Tirupati, and PhD from Osmania University, Hyderabad. Sir was the head Department of Law, Osmania University from 2008 to 2010. He was also the Dean Faculty of Law, Osmania University, 2012 to 2014. He was also the Dean Faculty of Law, Satavahana University, 2012 to 2017. After 2017, Sir was the Principal of Pendikanti Law College, Hyderabad, from 2017 to 2020. He was also the former Dean Research, Maharashtra National Law University, Aurangabad. He is also the Member Executive Council and Academic Council, Chairman Academic Committee and Board of Studies from April 2022 till date at Maharashtra National Law University, Aurangabad. Sir has more than 20 plus research publications in various national and international journals. Sir's areas of academic and research interest includes constitutional law, family law, alternative dispute resolution, and law of evidence. With this brief introduction about our resource person, sir, I welcome you again to this final day of 3-day webinar on new criminal laws. It's our pleasure to host you, sir. Over to Ragini.
Thank you, Krishna. Today is the third day of the webinar. For last 2 days, we have learned about the overview of the Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita. Today, we are going to learn about the new challenges that we have faced and the reforms that happened in the Evidence Act. From the admissible evidences to proven fact to what the importance of the police confessions are, the oral evidences, how the changes has happened in the Bharatiya Sakshya Adhiniyam. We are going to learn today from our esteemed resource person, Dr. Y.F. JAYAKUMAR sir, about the clarity of the Evidence Act now. Over to you, sir.
Thank you. So please ensure me whether I am audible to you first.
Yes, sir, you're perfectly audible, sir.
So here, because of some rain, then Geo internet has gone. Now I'm just relying upon my mobile phone, and not my phone and my neighbor's phone. Okay. So these are the state of affairs when webinar is conducted. So generally, without any contradiction, I say I'm against to all these webinars. So this reason is, I think that even our universities that we do it, there is no any personal interaction, is it not? But anyhow, when the resources are not there, it is always better. Something is better than nothing, right? Anyhow, I am very happy that the university, Central University, Gulbarga, is doing a wonderful job by organizing a webinar on the new criminal law that recently they brought in. So at the outset, I thank the dean and the coordinator, and I am also thankful to the participants to join with me. And I greet the occasion and my wishes to all the participants, because I'm an old man. Okay, right. So the topic today, the chosen topic today is Bharatiya Sakshya Adhiniyam 2023. So the participants and those who are actively involved today, they are heterogeneous group. They are from different disciplines and different states, and also different places of learning. Now, keeping these backgrounds of the target group, let me confine my presentation is only on the basic facets of the topic, rather than go into the issues, intricacies, and challenges. So this is, I think your expectation is also that to look into the basic aspects of the present topic, that is on Bharatiya Sakshya Adhiniyam 2023, that is BSA. It is an overview. So before we examine the salient features or the basic aspects of Bharatiya Sakshya Adhiniyam, I want to share few things, what we call introductory aspects of the Indian Evidence Act and also Bharatiya Sakshya Adhiniyam. See, the Indian Evidence Act, now we are calling it as Bharatiya Sakshya Adhiniyam 2023. It is, this is the law that governs the facts of inquiry. So this point we have to keep in our minds. So this is the law that governs the facts of inquiry. Similarly, this is also the law that governs the facts of admissibility. And if you go to the further, that is, this is also a law that governs the facts of relevancy and examination of what we can say witnesses. And finally, this is also the law that governs the facts of what we can say the proof, facts of proof. So therefore, whenever I am there in the class, in the very first class, I give one SMS message, a short message with a formula to the students. What is that formula? To understand the intricacies of the Indian Evidence Act is RAE is equal to P. This is the formula that I advocate. So if you go through the entire Indian Evidence Act, or if you go through the entire Bharatiya Sakshya Adhiniyam 2023, the outcome is only this. What is this is called RAE is equal to P. So what this R stands for relevancy, A stands for admissibility, E stands for examination, and the result is the proof. What is that proof? Is proof of facts, relevancy of facts, admissibility of facts, examination of facts, and ultimately what we get is what is called proof of facts. So this is the purpose of the legislation. So this is not a substantive legislation, that is a substantive legislation. It is only a procedural law. Of course, here and there where we can find some substantive provisions. It's not a substantive law. Basically it's a procedural law, but we have few what we call areas where the substantive provisions are also there. Right. So now, at present, we have the Indian Evidence Act. Even today, we are governed by Indian Evidence Act 1872. Right. So there are the so what is this purpose of Indian Evidence Act is to help the courts to determine the existence or non-existence of facts in inquiry. So this is the basic tenet of the act, to what we call to determine the existence or non-existence of the facts or facts issue in a case or proceedings. Now, this act has undergone certain changes. I am not using the word major changes. So if anybody says that there are major changes, that is, I am against it. There are certain changes. They are not substantive changes, but there are certain basic changes that are some important changes they have undergone. Right from 1872 to present, that is called 1872 to that is 2023. So first we'll focus upon what are those changes. Then, so the major change, that is what we can say literature change. Well, I call it as a literal change or grammatical change, that what is called in the year 2023, that is Bharatiya Sakshya Adhiniyam. So if you go through the Indian Evidence, that is Bharatiya Sakshya Adhiniyam 2023, and where you cannot find any structural or functional or not normative changes in the act. So this is a very clear, that is as a senior teacher, after going through the act of this 2023, my opinion is there is no any structural change, there is no any functional change, there is no any normative change, but change is there. The first change is the title itself. What is the title is? Bharatiya Sakshya Adhiniyam, that is 2023. Then after that, if you investigate, if you go into the substantive part of the acts, that where you can find few changes here and there. those things I noted, and I want to place those things before you as a salient features of the present legislation, that is 2023. Friends, my dear friends, before we look into the salient features or the substance, or what we can say, certain functional changes that they are made in the Act of 2023, I would like to draw, I want to draw your attention on the objectives and the reasons for enactment of the Act of 2023. Put into a different way, after a careful reading of the Act of 2023, so that is Adhiniyam, that is, I understood what are the aims and objectives with objectives. So as per my knowledge is concerned, there are 10 reasons are there. There are 10 reasons for enactment of this new legislation. So this is the first reason is, just if you want to note down, you go to the first slide, my dear friends. First reason is to replace, rationalize, restructure, and modernize the colonial law that is there in India. So that is, what is the colonial law? 1872 law is a colonial law, that is a British law. That we want our own law, that would be the purpose of the governments. Our own law, that is just by putting the name, that's the title, Bharatiya Sakshya Adhiniyam, then we are owning it is our law. That is replace, restructure, rationalize, and modernize the colonial law in India, or the colonial laws. I am using the plural here because IPC is there, CRPC is there, but this is one of the laws here. And the second important objective of this, or the reason for enactment of this legislation, is to meet the modern and contemporary issues and challenges with respect to admissibility of evidence. I already told you, the very purpose of the Indian Evidence Act is to examine the existence or non-existence of facts in the court of law. That is the purpose. It is a game. For a game, there are certain rules and regulations are there. So rules and regulations are there that we have to follow. And the thirdly, that is third important, is to provide general principles and rules of evidence, general principles and rules of evidence to ensure fair justice. So one of the objectives in the objectives clause, it is mentioned, fair justice we have to provide by using the new law. And fourthly, that is the fourth objective or the fourth reason for enactment of this legislation, is to meet the technological advancements. So we have the technological advancements are there, e-documents are there, what we call this content is there. So now what is happening, that you are sitting somewhere and listening to me. Earlier, this practice was not there. Eye contact. I used to keep every student. There are 222 participants are already joined, but I don't have any eye contact with you. But here, so everybody is seeing me. Everybody is listening to me. That is what we can say. Technological advancement have come in this country to what we in the recent times. Therefore, to meet those challenges, particularly in admissibility of evidence, or what we can say examination of facts and admissibility of evidence, this is very important. Then fifthly, what is the fifth objective, is to meet the corresponding changes already done or proposed, corresponding changes already proposed in BNS and BNSS. What that BNS, already you told that the Bharatiya Nyaya Sanhita, that is IPC. In IPC, there are certain changes are made already. I think that the day before yesterday that we would have discussed it. And Bharatiya Nagarik Suraksha Sanhita, this is the CRPC. So whatever the changes are made in CRPC, whatever the changes are made in IPC, so to meet those changes, what we can say, these changes are made in Bharatiya Sakshya Adhiniyam. These are the 5 objectives. Then I add 5 more objectives. So after a careful reading of the literature is that, so this will help, this Bharatiya Sakshya Adhiniyam will help us to assist operational dynamics of the substantive law and procedure law in finding facts and facts in issues. So the very purpose is to find the fact in issues, make it relevant, and examine it, and ultimately prove the existence or non-existence of facts. Then the seventhly, that is the seventh objective of This legislation is to expand the scope of admissibility of electronic and digital records. So this is electronic and digital records has given a very important place in this legislation. I think that is also copied from the previous legislation. So I think there is nothing is new, even in the case of electronic evidence. So this is to expand the scope and admissibility of electronic and digital records as evidence on par with the other records. So whatever the primary evidence that we have, whatever the secondary evidence we have in the form of book or chart or plan or map. So this is what we call the same thing where there is an electronic evidence. On this electronic evidence that we take into consideration, and this is one of the important aspects. Then eighthly, to expand the scope of secondary evidence. So here is predominance is given to the secondary evidence when we compare with the earlier the acts. So this is also that we will examine, or maybe the salient features we can I can explain to you. Then the ninth important aspect is to permit or allow the appearances of the claimants. So appearance in the court of law. Please, appearance means appearance in the court of law. And who are those people? Are the claimants can appear, accused can appear, experts can appear, witnesses can appear, and victims can appear by what? By what? Appear physically? Appear
by video conference.
that is what the Central University is doing. Central University is doing. So here is the technology. I am talking about the civil cases, not in all criminal cases. Only in civil cases where the witness can be seen, witnesses can appear before the court of law, experts can appear before the court of law, or victims can appear before the court of law through electronic means. This is one of the radical what we can. I'm not using the word radical changes because the act is already there. Information and Technology Act 2000 is there. 2000 Information Technology Act 2000 is there. So therefore, this is another reason, another objective of this legislation. Last but not least, to put the limitations on the facts for relevancy and admissibility. So the limitations that we are putting it. You can't bring the entire universe. Whatever the facts available in the universe, you can't bring it. We have to put the limitations. Then only that's called we can get the correct, what we can say, information. Then only we can go to the correct interpretation. Then only we go to the correct application of the facts, and then only we will get the result, what is called as the proof. So, my dear friends, these are the what we can say the objectives of the present governments to propose this legislation. This legislation is not at all implemented. We are waiting for the notification. Once the notification is issued, and from that date only it will be applicable. But whereas in the central universities or central institutions, the government has given a directive, or it has given directions that this legislation should be discussed with the participants or with the target groups, and what we say with the the target group, maybe in the universities or maybe in the institutions of public prosecutions, etc. So this wide publicity should be given. So with this reason, I think that what we call the Central University Gulbarga has conducted this webinar program. So these are the 10 objectives that I identified after careful reading of the literature available, and also this what we call the BEAR Act. So that is the proposed BEAR Act that I have seen. Now, let us go to how the old wine is brought into the new bottle. This is what the students have to examine. So the student, as I already told you, the student is a not homogeneous group. It is a heterogeneous group. Some people are there in the learning stage. Some people are there in the social sciences. Some people are non-law students are there. So for your convenience sake, I draw your attention how this old wine, that is 1872, is brought into the new bottle, that is 2023. So this is a clear statement without any contradiction. This is a old wine brought into the new bottle. So there is much ado but nothing. So I will examine. We'll see much water has flown under the bridge from 1872 to 2023. So that is number of amendments were brought to the Indian Evidence Act 1872. Number of amendments. So the major amendments to the Indian Evidence Act was brought in the year 1983 as a result of the famous Mathura's case. That was earlier also a few amendments were there, but they were not major amendments. Only what we call grammatical or structural, functional changes. Nor brought into the 1872, that is Indian Evidence Act, was law within brackets. The next slide. Criminal Law Amendment Act 18. Amendment Act 1983. What is this Mathura's case? How many are Mathura's case? Mathura. State of Maharashtra versus Tukaram. The students of law evidence, they know it very well. Where a girl, a tribal girl, an innocent girl, went to the police station at the sunset to give a complaint along with the parents. After the constable and the head constable, that's the police personnel in that police station, they said, you the parents and you the relatives, you go away. We want to, what we can say, put certain questions to this. Then the parents were away from the police station. They are staying or they are sitting nearby the police station. So it's a walkable distance, or where we can also call and where they can respond. But point was that during that period, that is maybe these two constables, one constable was in a full of intoxication, and another constable that he was in semi-intoxication, and they committed what you can say, one constable committed a rape against the girl, and one constable committed the outraging the modesty of the girl. Now, so when the public resisted, or where there was a public opposed, and so in that situation, what was happened? No, the case was registered, FIR was registered by the police, the same police on the what we can say on the same what the accusers are the constables. So this is a self FIR, right? So when the matter went to the trial court, and this is what it was done. Trial court. Since the parents are staying nearby, or what we can say they are sitting nearby the police station, there was no any alarm from the girl was done. If what we can say the Eligibility Act was done, and there was no any resistance from the girl side, and what we say there were no injury. The medical report saying, moreover, this girl was a habitual offender, habitual sex worker, and therefore it was closed as that it was a voluntary, and consent was, but not it was not a rape. So now when the matter went to the Maharashtra High Court in 1772, and where it was reversed and said, no, here is a case of rape. The reason is that what is a passive submission of an innocent girl, and it was a passive submission, it's not a consent. A wonderful interpretation was made. So a interpretation was done by the Maharashtra High Court. But when it went to the Supreme Court, that is what we call grammatical interpreted, and categorically states this is where the prosecution failed to establish that it is a are there under section 375 and read with 376. So therefore, those ingredients are not fulfilling. That is why benefit of doubt is given to the accused person, where the accused person was left free. So Tukaram and his friend. Now there was a hue and cry from the public, and also the representations were given to the Supreme Court. And finally, and after the result of this, what we call the public opinion and what we call, say, NGOs protest, and the year 1983, an amendment was brought into the Indian Evidence Act. That is, section 114A was added. You please read, my dear friends, 114A. 114A speaks about what we call shall presume. So in case of absence of consent in a custodial custodial rape cases, the rape in the custody of the police, where the rape was committed in the custody of rape was against the pregnant woman. In such a case, the burden of proof lies on the accused person. Shall draw an inference unless until it is disproved. So here earlier, what is the general, the criminal law principle on whom the prosecution accused person is innocent till it has to be established, till what we call the fact has to be established. But here it's a burden of proof is lies on the accused. The court shall draw an inference. It's not the inference that where the prima facie case is established that there is a rape case, and particularly also workplaces and gang rape or pregnant women, on all these cases, this is called, a title was given, custodial rape cases. This was a very important change in the Indian Evidence Act. Now you see the same language is used in 120, 120, Sakshya Adhiniyam as it is. So now whatever it was done in the 1983, that was replaced. Earlier it was 114A. Now it is section 120 of the Bharatiya Sakshya Adhiniyam. This is number one. That is the old wine in the new bottle. The second one is, second important change, Dowry Prohibition Act 1961. So as a result of Dowry Prohibition Act 1961, there are two important provisions were added to the Indian 72. Two provisions were added. What are those two provisions? One is section 113A, another one is 113B. Pardon? Pardon? Was correct. Right. See, you have any questions and queries, you put me later. The reason is there are 300, more than 300 participants are there. So I can't what we call address, or I can't give any answer to those people by keeping the others silent. Okay. So therefore, you please write. So 113A and 113B. 113A speaks about what we call presumption as what we call presumptions as to abatement of suicides, where the suicide was committed by a married woman within 7 years. This is a mere presumption. Presumptions as to abatement of suicides. So that is married women within 7 years of age. This is a mere presumption. So you know, court may presume or may not presume. depending upon the gravity of the situation, depending upon what we call the circumstances, court may. Once the inference is drawn, it is the duty of the opposite party to disprove the presumption. So here is the may presume. When it comes to section 113B of the Indian Evidence Act 1872, so this is nothing but where there is a dowry death, where there was a demand of dowry death, or the prima facie case of demand of dowry death was there, and where the accused persons are the husband or her relatives, close relatives, and the court, after a prima facie case is established, it shall draw an inference that is called shall presume, and once the shall presume is drawn, and it may be it should be disproved with the help of other evidences, but the burden of proof lies on the other party. So this is these 113A and 113B are reflecting, that is 117 and section 118. Section 117 and 118. So earlier I already given that is 120, that is section 114A, 120 is there. Now 117 and 118. That is another what we call bottle that they prepared and wine was done. That's what we call new wine. So old wine is the new bottle. Then next one is very, very important is that of course we deliver a separate lecture on that. That is Information and Technology Act 2000. So that is as a result of Information and Technology Act 2000 and section 65A and 65B were added for admissibility, for relevancy and admissibility of electronic evidence. So this is electronic evidence. So 65A and 65B. Now those 65A and 65B are reflecting in section 61, 62 and 6. So now 61, 62 and 63 are there. These are the three provisions. As it is, whatever the language there in the 65A and 65B previously, that is Indian Evidence Act, the same language, the small modifications, please understand, small modifications, as it is reproduced, in these sections 61, 62 and 63 of what is that called Bharatiya Sakshya Adhiniyam. This is also another important what we call aspect that we discuss when we are talking about the new legislation, the proposed new legislation. Then next one is Indian Evidence Act within brackets amendments 2022 was done. 2020 was done. 1 minute. Am I audible to you?
Yes,
Yes,
yes.
sir.
Yes, sir.
Right, right.
Sir,
Okay,
Please
thank you.
continue. Please continue, sir.
Something, okay, something is disturbing some. Okay, the next is Indian Evidence Act within brackets Amendment Act 2002, where a provision was added to section 146, clause 3. What is this 146? 146 speaks about what we can say the shaking the credit of witnesses, So where the victim is there in the witness box, that what we call, so when we are examining the character, that what way it can be shaken. So the victim's general and immoral character, there's a provision speaks out, the general and immoral character cannot be questioned here, and the previous sexual experience also cannot be questioned in the court of law. So this is where in the form of cross examination. This is what 2002, that is what we call the privacy is given to the women. You know that there is a case, a very important case, State of Maharashtra versus Madhukar Narayana. State of Maharashtra versus Madhukar Narayana. You go to the next slide where you can see State of Maharashtra versus Madhukar Narayana. And in this case, what the Supreme Court categorically said was that a women of students of constitutional law, they know it. The students of women in the law, they know it. So what it said is, what it is categorically, that a woman of easy virtue has a right of human dignity. So just because she is a prostitute, professional prostitute, and a character, easy character, or what we can prostitution, you cannot put whatever the. Now, what we have discussed is, what are the important aims and objectives of the legislation? How legislation has or normative changes through the Indian Evidence Act 1872, and how those provisions were incorporated into the present law, that is what is called 2023. This is what we say, the persons who are well learned and those who are having some familiarity with the Indian Evidence Act, they can understand. Now the people who are not at all what we call connected to our subjects, and they are social science students are there, and those first year students are there where law of evidence was not taught. For those people, 10 to 15 minutes presentation will be there, and I'll go to this, then I'll go to the interaction. So this is nothing but the salient features of the BSA 2023. Salient features. Suppose in the examination, a short question is asked. So what are the important changes that they have brought into the Act of 2023? And this is that is known as Bharatiya Sakshya Adhiniyam. Then anybody can write these things. There are 10 points are there, and those 10 points that just I want to explain to you, my dear friends, in a simple way, with a coherence. The first one you can write without any contradiction. The Indian Evidence Act is completely replaced. Please understand, completely replaced with a title as Bharatiya Sakshya Adhiniyam 2023, but changes, or what we can say, 90% of the previous provisions, 95% of the previous provisions were retained as it is. This is the Evidence Act is completely replaced, applicable to all proceedings, including court-martial proceedings under the Army Act, Navy Act, Air Force Act, but not to the affidavits and arbitration proceedings. So this is the second observation. First observation is, so that is the old act as it is retained. So only 5% changes where we can see. And the second observation is, the act is applicable to all proceedings, including court-martial proceedings. They are court-martial proceedings, that is called Army Act, Navy Act, Air Force Act, but not to the thing to do with the CPC and the Indian Evidence Act. At the same time, so this the third important feature, all definitions were brought into section 2 of the Indian Evidence Act, all definitions. So all salient features, first slide. Earlier, the definitions and interpretation clause was there under section 3 of the Indian Evidence Act. Please understand, section 2 was vacant. It was a repealed provision. It was vacant during the British period, something that we have did it. So it was kept vacant. Now, all the definitions. So what is a court, what is a fact, what is a fact issue, what is relevancy, all these interpretations clauses were brought into section 2 instead of section 3.
Earlier students used to go to section 3 for interpretation class. If they want any meaning, they want any definition, they go to section 3. Now you have to come to section 2. This is, I think it's not a normative change. It's only a functional change. Functionally, there is a change. So this is, or we can call it structurally, there is a change. What is the change is? So instead of section 3, come to the section. Important definition, special focus that we have to make evidence and the definition of documents. You please go through these new provision and read it. What is the definition of evidence and what is the definition of document? So the definition of evidence includes electronic and digital documents. Earlier was also there in a different form. So this in a different form. Now what we say clearly, conspicuously, it is mentioned electronic and digital documents are also documents within the meaning of the word document. What is the document? That what we used to discuss is anything is expressed or described on any substance for the purpose of recording. That is called anything is expressed or described on what they describe on any substance for the purpose of recording by way of letters, figures, or by lithography, whatever it may be. So the same document, whatever that we are having, prom 0 note, mortgage deed, all these things, whatever the deeds are there, the same electronic deed is also given the same importance. This important observation that I would like to draw your attention as far as the Act of 2023 is concerned. Then document, that is also digital documents, digital records that we have to make it. That is why in the illustration, it's given example as electronic records like emails, server logs, documents on the computers, laptops, smartphones, messages, websites, and the locational or like evidences and voicemail messages stored in a digital devices or documents. So this is an explanation given so that it's very clear. No ambiguity. What is a document? Previously, we used to be the clear illustration is given. It's only illustrative, but not exhaustive. So from time to time, where the changes may differ. That's where I like this area, particularly presumption, presume, shall presume, and conclusive proof. But all these presumptions were defined under section 4 of the Indian Evidence. So those presumptions were also brought so they in the new law, and you need not wait, you need not go to separate provision in the definitions itself.
Excuse me, sir.
Alphabetically, you go and search. Pardon? Now, hello. The voice is not clear. Okay. Wait. Few minutes. Now, is it okay? Right. Now, it's okay?
It is audible, sir.
Thank you. Just right. Thank you. Thank God. So here is, I'll repeat the provision. Previously, there was a provision, that is section 4 of the Act, that was speaking about the definitions of may presume, shall presume, and conclusive proof. Now there is no separate section for the presumptions. They are brought into section 2, and where the definition clause and alphabetically they are arranged. But alphabetically arranged that way we have to. Where we have to search next. The other observation is that relevancy of facts. This is the heart and soul of the Indian Evidence Act, my dear friends. Please repeat the presumptions since. Okay. So one of our participants is asked, that is, repeat my observations on presumptions. My dear friend, previously, the important three presumptions under the Indian Evidence Act, they were incorporated in Section 4 of the Act, Indian Evidence Act 1872. Now, Section 4 is these may presume, shall presume, and conclusive proof. They were brought from 4 to Section 2, and they are also incorporated under the head definition clauses, or what we can say interpretation clauses. Okay, so this is so now you need not read Section 4 now. So 4 is replaced now. Where you can find in Section 2 itself. This is another important observation. And next one is relevancy of facts. Previously, there was a chapter under the Indian Evidence Act that was known as Chapter 2, and Section 5 to 55 of the Indian Evidence Act speaks about relevancy of facts. In the entire Indian Evidence Act, my dear friends, if anybody say which is important, and any law student can say without any contradiction, that is 5 to 55. That is the heart and soul of the Indian Evidence Act. If a person is a mastery against the mastery over the Indian Evidence, that is a 5 to 55. I think that it is easy to the student to interpret what the Evidence Act is. So this was very, very important. The part, almost all the teachers will emphasize how to interpret it. So what it speaks is how to get the facts relevant to the fact of the issue. How to get the facts to relevant to the other facts. This is the game. This is what we can say the game, the rules of the game. The judge shall observe, a neutral observer, that he will observe that how the rules of the game that he has to follow. So there is it is a contesting case. One party is the one side, that is called a plaintiff. The other side is there. Those parties, they invoke the provisions of the Indian Evidence Act 5 to 55. They say, sir, it is relevant under Section 10, relevant under Section 12. Now it is the judge has to apply his mind whether they are relevant or not. So if they are relevant or not, it has to be examined. This is a very 27 is there. Sorry. It is already written. From Section 3 to 50, these relevance facts are there. Now, students of this new law, what we call it as Bharatiya Sakshya Adhiniyam, that you have to concentrate on the interpretation of the provisions from Section 3 to 15, how this is very important. And this is another observation. Another observation where it is not there in my PowerPoint presentation, just to add it. Another observation is, previously admissions were there from admissions. That is the rules of admissions, how to get the evidences. Admissions were there from Section 17 to 17. From Section 17 to 31 is there. Now it is replaced from 15 to 27. 15 to 27. There is a small change. They are all what we can say structural changes. No normative change. Normative change means the complete law has changed. Complete new law is given. So they are all normative changes. If you read that language and this language, the language is the same. Maybe sometimes where the grammatical changes that they made it. So there is even grammar also that they have not, because it was done by what we call Stefan. is a scholar or what we call a jurist that he had done it. So therefore, and our people have not done even the grammatical changes are also. So it is only structural new Evidence Act.
Sir, if it is possible, can you exit and rejoin?
I want. Okay. So you want to exit and rejoin, but I need.
There is some, sir, some network issue at your end, I guess. Sir.
Yeah. Now, is it okay?
Yes, sir. Yes, sir.
Is it okay? Right. Thank you. Thank you. So I'm almost coming to the conclusion. Right. I think we have only few slides are there. Then after that we close it and then we go further. See, another important observation is, so you please listen to me. Structural, functional changes here and there they made. Structural changes. What is the structure? What do you mean by structure? Instead of section 3, they made it as a 2. It is a structural change. Functional changes, they made it in some way. But the normative changes, what do you mean normative changes? Completely rewriting the law. So completely rewriting the law is not happened in the present legislation. This is my observation or my submission. Okay. Then another observation is confessions. Now specially incorporated in section 22, 23 and 24. Section 22, 23, 24 of the new legislation 22, 23. So the old legislation that you forget about that is also structural changes. And the expert's opinion, what is that expert? Who is an expert? Could you respond to me? Who is an expert? A speaker is not an expert.
Spatial knowledge or any.
Right. Okay. Right. All right. Previously, section 45 speaks about. Okay. Right. Just section 45. 45 of the Indian Evidence Act speaks that a person is an expert who is a specialist skilled in foreign law, art or science or identity of handwriting and finger impressions. This was so a specialist skilled in foreign law, art or science or identity of handwriting and finger impressions. So specially skilled in science is sufficient. The other things need not be. So everything will come under the science. So therefore that interpretation that we make it. So we have two provisions previously, that is 45 and 46. And those two provisions now incorporated into one provision that is called structural change. And it's called functional change. So that is under section 39(1), 39 within brackets 1 and 39 clause 2. So this is who is an expert and who is how the relevancy of expert's opinion, and also if there is any contradiction. Section 39 clause 2 speaks about the contradiction. Suppose one expert says that is a particular person is died because of the administering the poison. Other person says no, it is not a poison. It is only what we call a very delicious food, so that he may not die with that what we call that bottle of liquid. So where the contradiction is there between two experts, and that will be referred. Now we have the two provisions are there, the contradictory provisions are there. Section 39 within brackets clause 1,
and Section 39, Clause 2. Then another important is called a judicial notice. What is this judicial notice? So in Section 51, 52, and 53, what they did was certain words were there that is unnecessary words. This is a very, very important. This is what the real Bharatiya Sakshya Adhiniyam. What is the one of the objectives of the Bharatiya Sakshya Adhiniyam is? But the first objective that I explained to you is that restructure, replace, rationalize, restructure, and modernize the colonial law. That was the one of the objectives. So it is done here. What is called, for example, certain facts are not at all relevant to the modern day. What is the facts are? UK laws of the Parliament, court proceedings of the United Kingdom, and official seal, authenticity of the official seals of the United Kingdom, and signature manual of the United Kingdom. In what way they are relevant? So when I was a teacher in the university, National Law University, other universities, every year some students, they used to put questions, sir, so in what way they are relevant to us? Then we used to say they are dead letters in the Indian Evidence Act. You don't concentrate on that, but however, it is there in the syllabus that you have to read it. Tomorrow, whenever there is any question on what we can say, judicial notice and other relevant matters, then you have to identify the court shall take note of all laws in force in the territory of United Kingdom, all court proceedings of the United Kingdom, all official seals of the United Kingdom, all the sign manuals of the United Kingdom. So that is there, but it is up to the court, up to the Supreme Court and High Court that call to give any interpretation on that areas. So this is what we can say. Some of the changes that they made, they are deleted. Now they are deleted. There is no UK law. There is no UK Parliament law. There is no court proceedings of United Kingdom. There is no official seals of the United Kingdom. All these things, they are useless and they are removed. That extent, okay, I agree. This is a change. Then next observation is that similarly, there are certain words were deleted. Certain examples were deleted in the respective provisions of the Indian Evidence Act. For example, London Gazette and the genuineness of the London Gazette, presumptions as to documents in the England, cessation of territory, power of jury to put questions. Where is the jury now? Long back it is dead. So therefore, those words are also removed. This is even the 1872 legislation also, and they are all negligible. They are what we call nobody cares. Nobody is caring those what we call those words. But now they are officially and with an authenticity that what we call authority, they are removed. So those illustrations, London Gazettes, the presumptions as to documents in England.
1 second, sir. Your voice is not audible, sir.
Okay, we'll wait few minutes. Now I think it is sure. I think now, yes. Okay, very good. Next time you call me to Gulbarga on my own, what we can say, TA and DA will come and deliver lecture. This is horrible for me. I think really, I had tension because 250 students were waiting throughout India, different places. But I stood before this small computer or what we call small phone, and I'm unable to deliver my goods up to the mark. This is my feeling. Really, the coordinator and the dean, I am expressing my what we call sorry state, because it's a whiz major. It's not in my hands. So I have 3 computers are there in front of me. Everybody is trying to get to connect to this or that, but ultimately that I have chosen this. What is this phone is? It's an Apple phone is there. I think at least this Apple phone will help us, just like an Apple. Right, we are come to the closure, and the one we say certain nomenclatures. They are all nomenclatures. That is a barrister, vakil, attorney, pleaders. They are all what we call the remotes. They are no more in the statute book. Now, what is the name is tomorrow? Once you become you enrolled as an advocate, and you will become an advocate. And there is no question of barrister, or there is no question of vakil, there is no question of attorney, and there is no question of pleader, all these things. So this is advocate that this is the language that used it. Okay, in 2023 legislation. And next one is another observation is this is a little bit what you can functional and also normative. There is a normative change here. You please note down. Note this point is accomplished shall be a competent witness. Accomplished shall be a competent witness against the accused person, and conviction is not illegal if it is proceeded upon the corroborative testimony. So, my dear friends, Mr. Krishna, please display the last this one. In the last one, the last but one sentence, you please read it. This is very important. This is, I agree. This is not the old wine, and is the new wine and the new bottle. New wine and the new bottle. Accomplished shall be a competent witness against the accused person, and conviction is not illegal if it is proceeded upon corroborative evidence, corroborative testimony. Previously uncorroborated. The word un was there. So therefore, what is a who is an accomplice? He wants to do some that's what we call favor to the prosecution. Then shall we trust him? So what it says to the witness box and give.
Sir, please.
And then it is better to go.
Sir, can you please repeat, sir? Can you repeat, sir, please?
For corroborative evidence. Previously,
Sir, voice is
so
not clear, sir.
133 previously and 138 speaks about accomplished shall be a competent witness. Yes, yes. Wait. Right. Okay. Really. Sir, am I audible to you or not? Last point. I'm closing it.
Yes, sir, you're audible.
So you are audible, sir. Please continue, sir.
Accomplice is a person who did crime and witness is a competent witness. But corroboration means compare. And compare whether he is giving true or not. Then only it is a good evidence. Previously, what it was there, uncorroborated, even without corroboration. And other miscellaneous provisions, we have 170 sections now in the Bharatiya Sakshya Adhiniyam. 170 sections are there. Previously 167 was there, and now 170 is there. It's enabling provision. With these few remarks and observations in the new legislation and compared with the previous legislations, I take this opportunity to and the senior teachers who are all there sitting with you, and all I'm very happy. Now it is open to you, my dear friends, that you can put questions, but very few questions I allow.
Dear participants, you may ask if you have any
Mr.
questions.
Krishna, you take a lead to my presentation.
Yes.
Don't go to the CRPs and CPs.
Yes, sir. Yes.
Okay, your feedback and what you also appreciation, that's different, but if you want to.
Sir, there are some people who raised their hands.
Okay, then
Sir,
you take and
Rajeshwar Rao.
Yes, sir.
please.
Hello. Sir, my name is
Please.
Rajeshwar Rao.
Very good.
Yeah, sir, in the Evidence Act, you told the radical changes is happened it. And is a very welcoming decision of advocate. In many places, they are calling it the Pleader Act, right? Really, it is a great thing, 2000, at least 2024, 2023, this act is enacted and changed a little bit advocate.
Okay.
Act is already 1961 is there, but normally people are used to a pleader. If you go to the villages, always you say we want to go to the pleader, right? That vote the people. But how we are going to change to an advocate?
Okay.
People.
So I appreciate your observation. So it is the wisdom of barristers. I learned this barristers. All these things were there. Now it is a made test. That is everywhere that we have to use the word advocate. It's an advocate's act. Point in it. So not completely structural change. It's not a complete, but what we say, Bharati.
Okay.
The liberalization and what we can say globalization. So I appreciate your observation. Thank you. Next.
Yeah. Thank you so much. Thank you very much.
Right. Good observation.
Sir, Reena Pillai has a question. She's asking, what significant change would you have wanted in the act which has not happened, sir?
Right. Good. My dear friends, I am not praising the author of that is 1872, Lord Stephen. He was a great scholar and great jurist. Every care he has taken, because every care he has taken to draft the legislation to meet the needs of the society. That's what we call litigation. So what the Indian Evidence Act is not a substantive law. It is not giving any rights or immunities or privileges. It's not giving. It is giving only what, how to bring evidences. I already told you, RAE is equal to P. First you take relevancy of facts. Next you take the examination of facts. Sorry, RA, admissibility of facts. Then next one is examination of facts, and the result is proof. As far as the proof is concerned, Lord Stephen has taken a meticulous care. That is why Indian Evidence Act 1802 was considered as the grammar of the Indian law. The grammar of the Indian law is a grammar. So this is the observation. Many people have every care, contemplating the social needs. That is the language, how beautiful it is. You read section 11, previous section 7. So that's notwithstanding anything, what we can say, the previous facts not otherwise relevant become relevant. If they are inconsistent, highly probable, highly improbable, how beautiful that language is. Even today, that language is relevant. And if you change even one word, that what we call this, there is a possibility that it may be misinterpreted, it may be wrongly interpreted by the judges. That is why the professors who are set, what we call the members who are there, so they simply made small, what we call structural or functional changes, but normative changes. This is my observation. There is no need of what we call such changes, radical changes to be done here. This is that's Act of 1870. I know that we made such. So there is no any provision to go to the court of law and say that is what we call is a constitution invalid, right? This is my observation.
Thank you, sir. Sir, Munmun Sunil Tyagi, you may ask your question.
Okay.
Munmun Sunil Tyagi.
Yeah.
Anusuya,
Tyagi, what is your?
and you may ask your question.
Good evening, sir. I have a doubt regarding the section 133 and 138 of the comparison between 133 and 138.
Right.
So could you
Right.
please
Right.
elaborate it, sir?
Previously, the word uncorroborated testimony was there. B.
So your voice is not audible properly.
Just to convert to the prosecution side. I hope it's coming and going as well. Okay. So the teacher is hello. It's not coming.
You're
It's
audible,
okay.
sir, now.
Now audible. Lester, you listen to me.
Yes, sir, yes, sir, you're audible now.
Accomplish to allow accomplish evidence to make it relevant without matching, without taking the assistance of others, then that can be allowed and where the judgment can be given. Now what the law says, the new law, also take to the other evidence. Go to here and there, bring the corroborative evidence, match it, then only it will be a good piece of evidence. This is the difference. Okay.
Thank you, sir.
Thank you, sir.
Okay.
So Yogesh Kothari has a question. He's asking what extra limitations are imposed on presentation of facts, as old act already says only relevant facts can be presented or admissible. Kindly explain.
Once again, repeat.
What extra limitations are imposed on presentation of facts, as old act already says only relevant facts can be presented or admissible? Kindly explain.
Right. In the old act and the present act, the status is the same. The status is the same. 5 to 55 previously, 5 to 55. Now the present is what is the scheme is previously 5 to 55. Now it is 3 to 50. The scheme is the same. But point is, previously, whatever the facts that you are bringing to the court of law, you have to establish the relevancy under any one of the provisions. Please understand. So 5 to 55, forget about 5. So 5 is introductory provision previously. So here is at least one of the provisions. From 6 to 55, you have to invoke one provision and satisfy the court. Sir, here under section 10, it is relevant. The conduct is relevant. Under section 11, that is called alibi is relevant. Like this, we have to establish. My dear friends, very carefully. Even if you establish that facts and relevant, ultimately, to allow your evidence or not to allow your evidence, it is the discretion of the judge. Why? So it does not mean that the judge will go against the law. For example, if you want to bring
I'll tell you one example. In your college, in front of your college, an accident took place. And where in the college premises, there were what we call 100 students were there. 100 students were there. 100 students to the 2 PW3, PW are sufficient. One teacher, one student, and one employee. P. If these three, the prosecution or the accused person, they plead, that's what we call the other party, because they want to win the case. Sir, don't. I want all 100 students to be examined. All 100 students are this relevant. There is no doubt in they are seen. They are eyewitnesses. But only thing is, we have the limitations. That's what. How many number of evidences that we have to allow, and how many witnesses that we have to take it. So the same status even today. The discussion has not gone from the judge's hands, and it's nothing but section 5 to 55. Present. It is only the rules of the game. How you do it. The prosecution and the defense, the plaintiff and the defendants. These are the rules of the game. Within these rules that we have to what we have to play. And even if you play within the rules, discussion is there to the judge either to allow or not to allow. So ultimately, then you go to an appeal. Sir, this is what we call. Even if you are not, your evidence is not. Appellate court allow your appeal only when there is an interpretation of one of the provisions of the statute or interpretation of one of the provisions of the Constitution. It is interpreted by the magistrate, whatever is interpreted by the district judge, they are the final, because we take note of that the judges are using their wisdom as far as the identification of or what we call interpretation of the facts are concerned. Right? No change. Status. Next. Okay.
Mahadevi Hutagi, you may ask your question. Malishi Sajjanji, you may ask your question. Saeed Jilani ji, you may ask your question.
Ragini, I think that
Sir.
So they I think they.
Sir, there is a certificate at the end of that is section 172. I think it is with respect to production of some this thing is some device or something.
Right.
A schedule they have mentioned and a certificate under section 63(4)(c).
That is with regard to electronic evidence. Am I correct?
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Evidence.
Sir,
I think.
sir, what is this with respect to, sir?
Right. See, electronic evidence. Hello.
Okay.
Electronic document.
Yes, sir.
Is there in possession of the other party, third party. I want electronic document. I want electronic document. But the electronic, the doc is there, original is there, with my vice chancellor or with my registrar. So therefore, whenever I am relying upon electronic document, electronic records, the copy that I can submit it to the court, and what the this court is expecting from me is that original. So for that purpose, what I do is there is a schedule is there. There is one schedule is there. In that schedule, I fill it. Sir, this is not a professor in the university. I am having only secondary evidence. The copy of the document is there. The primary evidence is available with the registrar of the university. Then you please make your effort to bring that evidence from the what we call the registrar. So therefore, I'll what we can submit a declaration. I submit a declaration, and it is the court, it is the duty of the court to procure certificate. Then only when you get the certificate, then only your secondary evidence will get the evidentiary value, best evidentiary value. That is what secondary evidence. Only in case of secondary evidences. Thank you.
Okay, sir. Thank you, sir. Thank you. Sir, as you said, sir, I think this Evidence Act and IPC, they were drafted just 8 years or 15 years after Sipai Mutiny. That is, but still, even today, it holds good. But I think it is only for the sake of changing the name. They have given Indian names. Otherwise, as your good self told, everything remains the same.
Okay.
Thank you, sir.
Right. The IPC changes were made. In a CRPC changes are made. I'm not disputing it. But when it comes to the Indian Evidence Act, the same. That is what we as it is written, but the nomenclature, that's what the title is, Bharatiya Sakshya Adhiniyam. It's a Sanskrit word, and I'm using the word Sanskritization. Sanskritization. This is your local language from Mysore local language. Sanskritization, Brahmanization, urbanization. So these are all the words where we studied in the sociology, liberalization, privatization, all these things. Now what we can say, even the titles also we made it as a Sanskritization. That's all. Adhiniyam, not act. Adhiniyam means it's called act, ACT Act. Thank you.
Thank you, sir.
Thank you, sir.
Thank you so much, sir, for the informative session. You had really covered the whole act thoroughly. Thank you so much, sir. Now I invite Dr. Basuraj Kubukadi, sir, Dean of School of Legal Jurisprudence Studies, to give a closing remark.
Please.
Sir, very good evening.
Good evening. Thank you, Basarajji. Thank you.
Sir, a wonderful lecture you have delivered. And all the participants have benefited, and for knowledge actually enrich participants. So, but then you all the aspects, and many of the from physical programs, as you suggested, it will not be possible to elaborately discuss and to make the people understand through this online mode. As you have suggested, we will have sessions in a physical mode, and we will invite you. And now only I request you to spare some time for us.
Sure.
And
Sure, thank you.
As all the participants, yes, sir. Yes, sir. On behalf of the department and also on behalf of the Vijnaneshwara Pratisthana Trust, I wholeheartedly thank you, sir, for your valuable time with us. Dear participants, we tried to organize the webinar on these new criminal laws, and we invited a good resource persons. One is a judicial officer, one is a retired professor, and one is again faculty from NALSAR. And We will also organize these type of webinars in future also. So I request all of you to cooperate with us. And the Department of Law is a new one established in the year 2020. And we have organized different type of national level workshops, seminars, and also lecture series, FDFs. Many of the participants have benefited out of these programs, and I request all of you to be supportive for our programs in future also. Once again, for your interest and sparing time for this webinar series, I thank all the participants who have registered and joined and benefited out of these sessions. Thank you one and all for your valuable time, support, and guidance.
Thank you very much.
Thank you.
Thank you so much, sir.
Thank you, sir. Thank you.
Thank you, sir.
Thank you. Ragini, thank you.
Thank you, sir. So much.
Thank you,
Thank you
sir.
for your
Thank
special
you so much.
interaction with our resource person. Thank you for your wonderful.
Thank you, sir.
Thank you.
Yes, sir. Thank you,
Thank
sir.
you,
Thank you
Ragini,
very
madam.
much.
Thank you
Excellent,
very much, sir.
excellent coordination. And thank you very much for your patience also.